Welcome everyone to our LinkedIn Live. I'm Adam Bloomberg, Senior Client Success Advisor here at IMS, where we assist litigators in gaining a competitive advantage in the courtroom. Today we're speaking with Jason Barnes, Senior Strategy Advisor and an Emeritus here at IMS. With more than 30 years of experience, Jason has developed case strategies for countless arbitrations and trials for law firms and corporations nationwide. He possesses significant knowledge on how to simplify complex concepts, early case strategy, and his work with expert witnesses. He has extensive experience in the Eastern District of Texas, the International Trade Commission, and state courts throughout the country. Leading the discussion is our very own Chris Dominic, Senior Strategy and Jury Consulting Advisor here at IMS. Chris, over to you.
Thanks, Adam. Jason, how you doing?
I'm all right. How about yourself?
Good.
Wonderful.
I've been really looking forward to this. I'm not sure if I've actually ever asked you before. How did you get into this in the first place?
In 1998, I opened my company, Barnes & Roberts. And in 1999, we were hired by Jones Day to go to a patent case in Marshall, Texas, which was Texas Instruments versus Hyundai. It became the seminal case, the thing that started the IP revolution in the Eastern District of Texas. Now, as a result of that, I did a lot of work in the Eastern District and a lot of patent work that followed on with that because it's really right in my backyard.
Yeah, absolutely. What have you been working on lately?
Well, still a large part of my caseload is intellectual property, which I really enjoy working on. It's right up my alley. But these days I do bank and trust cases, I do general commercial cases, antitrust. I have still a couple of IP cases, but even white-collar crime is a thing that I found myself doing more and more of.
So you're still chalking up the airline miles, is what I'm hearing.
I have a few airline miles this year. That's certainly true.
One of the things you and I work on and have a real passion for is early case strategy work, real strategic orientation. I would love to hear some of your thoughts about what your passion is in that area right now.
Well, in terms of early case strategy, I like to, regardless of the case type, I like to look at a case and answer a few basic questions, really. Are we able to tell a story that satisfies the head, the heart, and the gut? And what I mean by that is, how do we win on the facts and the law, right? That's how we talk to people who make decisions based on sort of their head. Is this fair? Why should I care? Right, these are questions that I would ask about, to help satisfy people who make decisions, maybe a bit more on empathy and things like emotionally based people. And then, does the story we're telling pass the smell test? Does it satisfy your need for to understand the world like common sense? Right? Does this meet the requirements of common sense? Does it comport with how I experience life in the real world?
Yeah.
Right, and so you need to address all three of those things.
Yeah, it's funny. I was working on a job recently with one of your colleagues, and we were doing an opening statement preparation together. And one of the things I said was, this is a place where we should have no demonstratives specifically. And one of the things that made me really happy was we hadn't even talked about this in advance. I said, this is a place where I want the jury's eyes to go to the attorney, because this is a speech right now, and this is an important moment. And I look over at your colleague, and they just looked at me like, yeah. Like, it's not like they just want to put more graphics in all the time, right? We're both on the same page about what we're trying to do. We want that message to come across as best as it possibly can. I know you do a lot of opening work.
So I do, and it's important to remember that even though we call ourselves visual advocates, not everything we do is visual, right? It's a lot about the stagecraft. And the thing you were describing is about making sure where the focus is at any one time during an opening statement or during a witness examination, right? In some moments, it's important that there's nothing on the screen. There's nothing to distract the jury. There's nothing to explain. You only want eyes on the attorney. Then you're going to say, look at this piece of evidence. Then you're going to say, follow along on this timeline with me. But when you're done with that, you want the eyes back. Right? And that's so important to think about where people are, what they're thinking about, how they're perceiving this presentation that you're giving them.
Yeah. When we were talking earlier about our approaches, I remember thinking, we were talking about like what people say to us when we ask them, why aren't we doing work earlier? And what I've heard some people say is when they don't understand why I want to work earlier in the case, they'll say, well, we haven't even really gotten that far into discovery yet. And my answer a lot of times is, well, I want to make sure that we have an idea of what our story is, at least preliminarily, for the witness preparation session. I know with you, a lot of times it's going to be, how are we going to make sure that these expert demonstratives make sense? Can you talk a little bit about experts and the way that works?
So I do like to get involved earlier than later. And if someone says, oh, well, we're really not that far along, and my answer is, great, right? There's an opportunity to do some good work, right? And I in terms of visual advocacy, of course, there's always an opportunity to talk about thematic development, right? Hooks that you can insert either during your opponent's presentation, safe harbors that they can go to, but
Absolutely.
There's also hooks that you can get when you're taking depositions from the other person to get them to admit things in just the right way. So there's always a good opportunity to talk about that kind of strategy. But when it comes to the visuals, a lot of times we work with the expert witness in terms of their expert report to make sure that the charts and graphs and diagrams, photographs and videos of them capturing evidence as they're doing testing, for example, we want to be consulted on the best way of capturing this evidence so that it's useful not only to report, but also later at trial or to mediation, arbitration, things like that. We also are available so that sometimes you want to take a deposition of your own expert, or sometimes you want to challenge the other fellow's expert with some kind of graphics. It's very difficult for them to do. So we'll work on generating those graphics and figure out a way to present those at deposition, also to be captured in part of the deposition so that later on it can be used against them.
Yeah.
To get some admissions out of these people. So it's never too early to start thinking visually. I would just say this. If you can visualize it, if you can draw it, you can explain it. I always say to myself, until I can draw it for you, I don't understand it. Right? So visual thinking for me is just sort of an inherent part of the way I process the world. So for me, it's always good to think visually.
I saw something as I was walking through the office, and I told myself I had to ask you about it. Because I think this is one of those things.
All right.
You might need to hold this up for the camera at some point. This is one of those elements that I get so excited about. It is another different way to keep people's attention. It's another way to explain something. It's another way to take the experts and allow them to take something that's difficult or complex, simplify it for people. So could you give me the story behind this thing?
Sure. Let me set the stage a little bit more generally. When we talk about expert testimony, working with experts is an amazing and satisfying part of my career. They're so smart, and one of the best parts about my long career is having met some of the smartest people literally on the planet, and I love doing that. But their superpower is also their greatest weakness, right? I mean, and so they're used to teaching PhD candidates and writing for people that are at the same level of expertise or maybe just below where they are. And so they're caught in that deal. So we always want to talk to them about how they're going to reach the jurors, how they're going to reach the court as well, right? They have to satisfy the other expert and lawyer, so that they are, like, during cross-examination, the things they say hold up, right? They have to be scrupulously accurate in a technical sense. They have to be able to persuade the court at some level that they're credible and they have expertise. But more importantly than that, they have to be able to reach jurors where they are.
Right. It's at least three audiences.
It's at least three audiences. Yeah. And so it's very important that we're working with experts to prepare them for their testimony, that we consider their strengths, their natural proclivities. Are they good at teaching? Are they nervous teachers? Maybe we want to keep them in the chair, or maybe we want to get them out of the chair and let them teach. Can they draw on a whiteboard or a flip chart? Should someone else draw for them? Right? Should we practice that? Which I've done a number of times, teach people how to draw. It's not that hard. I can totally do it. Should we give them can they demonstrate a product, right? Can they show, like, if it's software, maybe there's a prior art software, can we boot up a computer and show it to people? In this case, we were talking about a device that was, on the order of about 1/8 of an inch square, cubed.
Yeah.
It was very small. We had diagrams and photographs and all kinds of evidence, but we wanted the expert to get up out of his chair and teach. Because we know that when you stand up and teach the jury, there's a moment created between the jury and the expert, or the lawyer, if you're in that mode, right? And so we wanted to it's interesting, the courtroom shrinks, right? So everybody else kind of disappears. It's only the person standing up there in front of them. We want it to be our expert. So
absolutely.
Sometimes we like to give an expert a prompt. In this case, because the device was so small, we used 3D printing, which at the time was quite new, to enlarge this device.
I think just make sure you get the camera there.
Sure.
Oh, there we go. Okay.
There we go. To enlarge this device so that we could explain to the jury. Now, I'm not going to explain the technical details of what's going on in here, but essentially this is, you can think of it as, it looks a lot like an integrated circuit. It's not. There's two magnets, two cores, right? So there's cylinder-shaped magnets, ring-shaped magnets. Electricity comes in one side, creates a magnetic field, which induces a current on the other side. So the signal comes in and the signal goes out, and yet the electricity from here never touches the electricity on the inside. So the outside world is disconnected in a way from the inside world so that you avoid electrical overload. Now, this is the super simplistic version, but that's what it was. We created two of these models, identical. One for the expert to hold and to teach to, and one to publish to the jury. So we passed it out to the jurors so they could hold it in their hands.
Get the tactile experience.
They could feel it. It was real to them. They could pass it one person to the next. They were making eye contact with one another, and there was a little sort of chatter, and I mean, not improper chatter, but they were kind of passing it one to the next. It was a social event in that moment. It was a great 10 to 15 minutes of trial that would be very difficult to forget.
Yeah. Oh, absolutely. That gets me thinking about, because it's so much fun for us to work together on these sorts of things. I was thinking about the time you and I talked about what we really think is our superpower, right? Which is this idea of we've got this big team, and when we get everybody working and we integrate with the trial team, and we're all basically strategic partners working together, we could just do these really amazing things. Can you speak a little bit in your own words about some of that?
Well, of course I said, it was my idea. It was my idea, but I'm not the only person who did this, right? It takes a whole team to think about the question, consider every part of it, and then to put it into action. So I like to think of this as a bit like eye-hand coordination. So when you and I work on a case, or I work on it with like a jury consulting person and a trial consultant or a visual advocacy person, you may have a great vision. I might have great dexterity, but without coordination, to put those things together, the eye-hand coordination, nothing gets done.
Yeah.
Right? And it's not only true that we have to coordinate among our own teams within IMS, which brings a lot of capability and experience and power along with it. There's a second part of integration that I think is ultimately more important, and that is the integration with our attorney team, right? That they've called us in to ask that. And we need to be available. We want to put all our skill sets, all of our experience, when needed, as needed, right? And that means early in the case. We talked about developing strategies for discovery, working with witnesses to prepare them for deposition, working with experts to get their expert reports not just done and on time, but full of things that are persuasive, right? For example, a bit of a side note is like your expert report is super important when you have a summary judgment motion. Your depositions in summary judgment, your summary judgment motion is really based on deposition testimony and expert reports, right? So you want to make sure both of those things are done correctly from the get-go, right? So early stuff is important. So the early part, the middle part for testing, for jury research, of course, your jury consultants are important, but you want to put your best foot forward to get all of the visual advocacy you can and to imagine what the other side might also bring to the table, to make sure that you are having a fair test, right? A fair fight, not only intellectually based on the facts and the law, all that stuff, but to put the visual advocacy fight also head to head as well. Get all that done. Plus, it's a great dry run in a way for your slides and your animations and all that stuff to have a testing. People like them. Were they effective? What would we do different? We're going to carry all that forward into the trial. So it's important that we're there throughout that entire time to do our best work. It's the greatest opportunity to have the most persuasive product that you can get out of consultants like IMS.
See, I knew you were going to say that better than I do. So, Jason, thank you so much for being here today and
of course,
speaking with me about this. I really appreciate it. And Adam, it's all yours now.
IMS has served trusted law firms and corporations worldwide for more than 30 years and over 65,000 cases. As a strategic partner for the full case lifecycle, our integrated teams provide specialized advisory support, expert witness services, litigation consulting, visual advocacy, and presentation technology to elevate strategies and protect hard-earned reputations. Learn more at imslegal.com.